Welcome to LexTalks Legal Topics Simplified, where we break down complicated legal stuff. And today we're going to be diving into
Why?
transfer by ostensible owner and transfer by unauthorized person under the Transfer of Property Act of 1882.
Wow.
So basically, it's all about who can sell property and what happens if someone tries to sell something they don't even own.
Right. It's a really crucial area of property law, especially in India. And, it's full of all these tricky situations and legal safeguards.
Yeah, like imagine someone selling a property they're supposed to inherit but haven't yet, or like
Yeah.
someone posing as the owner to trick a buyer.
Exactly.
Hmm.
Those are the kinds of scenarios we'll be untangling today.
Perfect. So let's jump right into it, starting with Section 41, transfer by ostensible owner.
Okay.
I think of it like that friend who borrows your car and acts like it's theirs, but with property and much higher stakes, obviously.
Uh-huh.
Yeah.
It's a good analogy. The core of Section 41 is that someone can appear to own a property, even sell it,
Hmm.
even if they don't technically have full legal ownership yet.
Right. They're like the ostensible owner.
Exactly.
But there have to be some rules around this, right? I mean, anyone could just come in and sell someone else's land.
Oh, for sure. There are some key safeguards in place. The ostensible owner needs to be in possession of the property. Like, they can't just be making claims from afar.
Right. Makes sense.
They also need to have the consent of the actual owner, even if it's implied consent.
Implied consent.
Yeah, imagine a family member who's been managing a property for years, even though it's not officially in their name.
So like if a wife handles all the business for their farm, even though the deed's only in the husband's name.
Precisely. That could be seen as implied consent. But here's the catch. The buyer also needs to have acted in good faith and with reasonable care.
Okay, so they can't just blindly trust the seller.
Right. They have to do their due diligence, like checking documents and making inquiries to verify the seller's authority.
So it's all about finding that balance, protecting the buyer, but also making sure they don't get a free pass to be careless.
Exactly. There's a really interesting case that highlights this, Najashar Prasad v. Rajapateshri, where the buyer relied on revenue records that turned out to be faulty.
Oh, no.
And because they didn't investigate further, the court said they hadn't exercised reasonable care and lost their claim on the property.
Wow, so lesson one for all the future lawyers out there.
Yeah,
Always do your homework.
absolutely.
But what happens if someone straight up sells a property they have no right to?
Yeah.
No inheritance, no nothing.
Okay, well, that's where Section 43 gets really interesting. This section deals with what happens when an unauthorized person sells a property but then later gains ownership.
Wait, so you're saying someone could sell property they don't own, hoping to inherit it later, and it might actually be okay?
It's not quite that simple, but essentially, yeah. Section 43 protects the buyer in these situations, but only if they meet certain conditions. The initial sale has to be for consideration, meaning the buyer paid something, not just a gift.
Makes sense.
And crucially, the buyer has to have acted in good faith, truly believing the seller had the right to sell.
So if the buyer had no clue about the shady dealings, they might actually end up with a valid claim.
Exactly. It's called the doctrine of feeding the estoppel.
The doctrine of feeding the estoppel.
It sounds fancy, but basically means the initial sale is fed by the seller gaining valid ownership later.
Okay, so give me an example.
Sure. Imagine a son selling his father's land before he inherits it. If the father dies, the son gets the property, and the buyer didn't know about the son's lack of authority initially, well, boom, the sale is retroactively made valid.
That's wild. So there's a legal principle that turns a bad deed into a good one, at least when it comes to property ownership.
Pretty much. But of course, this raises some questions like what if there are multiple buyers involved? Or what happens if there's a lawsuit going on during the sale?
Right. That's a whole other can of worms.
Definitely. And those are exactly the kind of scenarios we'll be digging into in the next part of our deep dive.
Okay, so buckle up, law students.
Yeah.
Things are about to get even more interesting.
So we were talking about how someone could actually sell a property that they don't own, and it might actually end up being legally okay later on.
Yeah, it's like one of those legal loopholes that makes you scratch your head.
Right. And it all comes down to Section 43, which deals with these transfers by unauthorized persons.
Mm-hmm.
To really understand this, we need to look at a case that shows this doctrine of feeding the estoppel in action.
Ooh, a case study. I bet the law students are loving this.
So there was this son, right? And he knew he was going to inherit some land from his father.
Okay.
But he was a little impatient, let's say.
Impatient how?
Well, he decided to sell off a piece of his father's land before he actually inherited it.
Whoa, hold on. So he was basically betting on his dad dying so he could make the sale legit.
Yeah, you could say that. Now, the buyer had no idea about this little legal issue and went ahead and paid for the land.
So the son was playing a risky game.
He was. But here's where it gets interesting. The father eventually did pass away, and the son inherited the property. And guess what? That initial sale, which was totally unauthorized at the time, suddenly became valid.
So the son got lucky and the buyer got to keep the land.
Exactly. The doctrine of feeding the estoppel swooped in and basically made the whole thing legit.
Kind of like the legal system saying, well, you got lucky, but the buyer acted in good faith, so we'll let it slide.
Yeah, you could see it that way. But
Yeah.
it gets more complicated. What if, after that son sells the land, he turns around and sells it again?
To someone else who has no idea about the first shady deal?
Hmm.
Oh, man, that's a mess.
It is, and that brings up a really important point. While Section 43 is designed to protect that initial buyer who acted in good faith, it can't just wipe out the rights of a second buyer who's also innocent.
Right.
So in your scenario, if the second buyer paid for the land, acted in good faith, A and D had no knowledge of the previous sale, their rights would actually come first.
So the most recent innocent buyer wins. That makes sense in a way.
It does, and this is where the idea of notice comes in. Yeah. In property law, notice basically means knowing about something. In this case, to be a bona fide purchaser for value without notice, that second buyer would have to show they had no reason to suspect anything fishy was going on.
So it's not enough to just say, I didn't know. You have to prove you were reasonably in the dark.
Exactly. They'd have to show they did their due diligence, checked the title, and didn't ignore any red flags.
This is getting pretty intense. So we've talked about ostensible ownership, unauthorized transfers, this whole feeding the estoppel thing. But how does this all fit into the bigger picture of property law?
That's a great question. These principles are all about balancing different interests in property transactions. It's about making sure things are clear, transparent, and that everyone's doing their part to ensure fair dealings.
So it's not just about memorizing legal terms, it's about understanding the real-life situations behind these laws.
Exactly. And in the next part of our deep dive, we're going to explore another concept that adds a whole new level of complexity to these property transfers.
Ooh, I'm intrigued. What is it?
We're going to talk about lis pendens, which basically means suit pending.
Suit pending.
It deals with situations where there's an ongoing lawsuit about a property, and that can really throw a wrench in any attempts to buy or sell it.
So even if everything seems fine with the seller, a pending lawsuit could still mess things up.
Absolutely. It's a reminder that property ownership isn't always black and white. There can be these legal gray areas, and buyers need to be aware of those before signing anything.
Okay, law students, this is where things get real. We'll be right back. Okay, so we're back, and we're talking about this lis pendens thing.
Right, lis pendens. It basically just means there's a lawsuit going on that involves the property.
So like if I'm about to buy a house and everything looks good with the seller, but there's this secret lawsuit happening.
Exactly. It's like a big warning sign to potential buyers
Oh,
that, hey, this property is tied up in some legal drama, and whatever the court decides could totally affect your ownership.
so it's like a ticking time bomb.
Yeah, you could say that. Let's say you buy that house anyway, thinking it won't affect you. But then the court rules in favor of someone else, saying they're the real owner. Well, you could actually lose the house even if you bought it fair and square.
That's scary. So lis pendens is basically there to make sure the courts have the final say on who owns what.
Right. It stops people from trying to get around the legal system by selling property quickly while a lawsuit is going on.
Right.
It ensures that the court's decision actually matters. You know, like that case we talked about, C. Ramswarn versus Sam Bandham.
Yeah, the one where the buyer got the property after a lawsuit was dismissed, but still have their claim challenged.
Right. That shows how lis pendens can still have an impact even after a lawsuit is over.
So basically, the legal history of a property really matters.
Absolutely. Okay, so we've covered lis pendens, which protects the people involved in a lawsuit. But what about an innocent buyer who walks into this mess? Are they just stuck?
Yeah, what happens to them?
Well, the law tries to protect innocent buyers, but there's also this principle of buyer beware.
Oh, yeah, I've heard of that.
Buyers really need to do their homework before buying any property.
Not investigate everything.
Exactly. Not just checking who owns it and looking for past shady deals like we talked about, but also doing a title search to see if there are any legal claims or lawsuits connected to the property.
So you can't just plead ignorance?
Nope. Not in property law. So basically, property ownership isn't always so straightforward. It's all part of this dynamic legal system, and buyers need to be aware of potential problems even if the seller seems to have everything in order.
A lot to take in.
It is. But that's what makes property law so interesting. It's full of surprises and challenges, and the stories behind those legal battles can be pretty fascinating.
Definitely. So we've explored all these different aspects of property transfer, from ostensible ownership to unauthorized transfers to that whole feeding the estoppel thing, and now list pendants.
It's been a wild ride.
It has. And I think it shows that while property law has its roots in history and all these old cases, it also has to adapt to the changing world.
Absolutely. We're seeing new types of property popping up all the time, like digital assets and virtual real estate.
Right. Like owning land in the metaverse?
Exactly.
Mm.
All of these things challenge traditional legal concepts. So it's a really exciting time to be studying law, especially property law.
Sounds like there's a lot to learn.
There is. But hopefully this deep dive has given you a good starting point.
Yeah, and a new appreciation for all the complexities of property ownership.
For sure. So keep exploring, keep asking questions, and never stop learning.
That's great advice. Thanks for joining us on LexTalks.
My pleasure.
Don't forget to subscribe and stay tuned for more deep dives into the world of law.